Whereas my learned friend dealt with the hearings in the High Court. But I want to show you what happened in the trial court. Because, as your Lordship knows, procedure is at the heart of liberty. Substantive law is one thing, but procedure is at the heart of liberty. That's why it says procedure established by law. Now, let's kindly see what has happened in the trial court. 55 dates of hearing of both the main matter and miscellaneous applications. Learned presiding officer was on leave for various reasons, including medical grounds and attending judicial training programs. Then, on 11 dates of hearing of both the main matter, on 11 dates of hearing on both the main matter and miscellaneous applications, the matter could not be taken up due to issues such as shortage of staff, personal assistant, ailment, and assistant ailment stenographer, and other such administrative and logistical exigencies. On 26 dates of hearing of largely miscellaneous applications, the matter could not be taken up due to heavy workload and paucity of time. Often the court was already engaged in hearing of both matters, as also the present matter was required to be adjourned due to lengthy argument, judicial work relating to the present case itself. The next is, Malas, very shocking. On 59 dates of hearing of both the main matter and miscellaneous applications, the matter could not be heard due to the unavailability of learned SPP.
That friend has given me a wrong note. It's
Sorry.
Not the note which you're reading.
So, learned SPP on various grounds. 59 dates, they sought adjournment on ill health, personal emergency, busy in another court, busy in High Court and mail matters, internet connectivity issues, no unavailability of assisting police officers. Another reason for adjournment on such dates is as if the prosecution sought time to file reply written submission. On 4 dates of hearing in 2025 onward, no hearing took place on charge due to lawyers' strike. Now, dates concerning arguments on charge. Now we come to the arguments on charge. The arguments began on 10/9. Learned counsel for Umar Khalid argued the charge on 7 days. Matter has been adjourned 6 times on 22/8, the date of which arguments on behalf of Umar were to begin. Twice on account of lawyer strike, once as counsel for Umar Khalid requested to begin arguments on VC, and the request was declined. Twice on account of counsel for Umar due to a conflict with another hearing, and once on account of learned presiding officer. So, in their counter, they say that I have been taking time and delaying the proceedings. I just wanted to record that. Now, the next note. I won't take long notes. Just give it. Just don't. Now, the charge against me is conspiracy. Only conspiracy.
You're appearing
for Umar Khalid. Charge appearing is conspiracy.
10.3.
And just note there are 10.3. I'm saying I said 10.3. There are 751 FIRs. I'm charged in one. If it's a conspiracy, Madas, it's a bit surprising, no, Madas? If I am the responsible for the riots. Now, just I'll quickly go through this. Petitioner was not present in Northeast Delhi from 22/2 and 25/2. The petitioner was not even in Delhi between 23/2 and 27/2. So on the dates when the riots took place, I was not in Delhi. Admittedly. No recoveries, weapons, arms, ammunition, acid, funds, or any other incriminating materials whatsoever have been made from the petitioner or at his instance. No physical evidence has been retrieved from the petitioner which connects the petitioner to any violence or writing. If I'm not there, how can I be connected? Not a single witness has given any statement that connects the petitioner to any actual incident of violence that ensued in Northeast Delhi. No allegations of the petitioner having procured, received, raised any funds for a terrorist attack. Importantly, no recoveries of any funds have been made from the petitioner or at his instance. 751 FIRs were registered in relation to the alleged incidents of 22/2 to 26/2. However, the prosecution has not relied on a single recovery or witness statement in any of the said FIRs to connect the petitioner to actual violence. Apart from the present FIR, the petitioner was only arraigned in one other FIR out of the said 751, being FIR 101 at Khajuri Khas, which dealt with a purported incident of violence on 25/2 in Khajuri Khas. Petitioner was granted bail in the said FIR by order dated that and was subsequently discharged by order dated 3/12/2022.
Yes.
Only overt act alleged against the petitioner is a speech delivered by the petitioner in Amravati on Maharashtra on 17/2. The riots took place, Mullahs, your lordship knows, from 23/2 onwards. I gave a speech on 17/2, and that is the basis on which they allege that I am the responsible for all this. And in that speech, Mullahs, I've said nothing. It's a public speech that I made, Mullahs. I've said nothing about any acts of violence or that any riots or that instigating people. A bare perusal of the which invokes Gandhian principles of non-violence and makes reference to the Constitution of India makes it unequivocal, clear that the same cannot be considered provocative by any stretch of imagination. Further, the same cannot come under the ambit of vague, overboard, and ambiguous phrase by any other means of whatever nature under Section 15. Now, this is important. Let us kindly just have a look at Section 15 for a minute. Not arguing merits, but I just want to show the definition of a terrorist act. Hello, Justice, may I have it? Should be page 12 of your book, hopefully it's the same. Joseph has 15. Whoever does any act with intent or threaten or likely to threaten the unity, integrity, security, economic security, sovereignty of India, or with intent to strike terror or likely to strike terror in the people of any section of the people or in any foreign country. Now, say, by using bombs. Admittedly, I've never done that. Death due to injuries, no allegation. Loss of damage or destruction of property, not responsible for any of that. Disruption of supplies to services, I'm not responsible for any of that. The charge is conspiracy, but I just point that out. Damage to monetary stability of India doesn't apply. Damage to destruction of property in India doesn't apply to me. Overalls by means of criminal force or show of criminal force or attempts to do so or cause of death any public functionary doesn't apply. Detains, kidnaps or abducts any person doesn't apply. What applies according to them is the last part. Or any other person to do or abstain from doing any act. This is what they say applies. Nothing specific.
All.
So, Maharaj, I'm not involved in the offense at all. And I'm there now for 5 years anyway. I just wanted to point that out. So it should be read as justum generis is my solution. Then, Maharaj, now regular bail was granted to 3 accused, Maharaj. In the note, there are only 2 mentioned, Maharaj, the 2 ladies, Devangana and Natasha. But there was a gentleman, Maharaj, Asif Iqbal Tanha, accused 1. Who was also granted bail. And this court upheld it. Asif Iqbal Tanha. Now, Maharaj, in the SSB filed by the prosecution, at the time of admission, notice was issued and it was said, granted bail, this should not be treated as a precedent. Then an application was filed. And then the court clarified it, namely that if the co-accused is entitled to a plea on parity, that is for him to make and the court to consider. So I was entitled to a plea of parity. Now, I am not present in Delhi on those days. Now, these 3 have got bail. And they were present. Not that I have anything against them. They were present and I am denied bail.
Same witnesses cited.
Same witnesses cited against me, same witnesses cited against them. Same evidence against me, same evidence against them on protected witnesses, 47 of them. 100 are public witnesses, 47 are protected witnesses. The High Court dismissed the petitioner's argument on parity by distinguishing the case against the co-accused and observing that the petitioner's role is prima facie grave in the entire conspiracy, having delivered inflammatory speeches on communal lines. With that only inflammatory speech is 17th of February. I have never delivered any other speech, not one, and that speech is not inflammatory. It's available on YouTube, Maharaj. High Court earned in much as the prosecution has contended that co-accused have also delivered purportedly profanity. We are not concerned with co-accused, Maharaj. I have never delivered any inflammatory speech. Then Mullah's facts. Arrested in 2020, 13 September over the page Mullahs. Spent 5 years, 1 month, 18 days. 18 accused to be tried together. 900 witnesses. Not a single witness examined so far. Stage of framing of charge. 3,000 pages of charge sheet and 30,000 pages otherwise. And after filing charge sheet, 4 supplementary charge sheets filed, which my learned friend has mentioned. Charges have not been framed yet, fine. Arguments and charge are going on, and the petitioner is, leave that up. Now, let's just kindly see, my learned friend has pointed out 3 judgments. I'll give you a compilation of those judgments. Give a compilation.
Yes, give the compilation, please.
What I've done is, brothers, for each judgment under UAPA, the term that the persons were under arrest and the bail granted, the pages and the paragraphs are mentioned.
These judgments are.
Now just see, brothers. Najib, 5 years, 276 witnesses, 3-judge bench, bail granted. 3-judge bench, bail. Sorry. Yes.
So index.
Index. No, just see the index. Yeah.
Yes.
So I was mentioning Najib, 3-judge bench, 5 years, 276 witnesses, left, charges already framed on 27/11/2020.
No, what do you mean by left?
I'm sorry?
Middle of trial.
Unexamined.
Middle of a trial.
Middle of a trial.
No, totally how many witnesses were there in this?
I'll just check.
We'll check.
We'll check and inform.
We'll check with informers, but there were too many 276 were left. 551. Just check. Then Tahua Fasal, 570 days, 92 witnesses, UAPA Mullahs. Charges not framed. Then Jahir Haq, 8 years, 103 witnesses left. Ravi Prakash, 3.5 years. Even in 3.5 years, bail was granted. 18 witnesses left. Means in the midst of trial with 3 years in incarceration, bail was granted. Then Mullahs, Muslim Alias, 7 years, 4 months, 9.5 years. Then Sheikh, my learned friend, is cited. Mullahs, 4 years, 80 witnesses, charges not framed. Javed Iqbal, 9 years. Salam, 4 years, 2 months. Angela Harish, 5 years. So, all the judgments and all the paragraphs, I don't want to take the time of the court. They're all set out here. Just
the seriousness.
And the court has said the seriousness of the offense is not relevant for the purposes of bail when he has been incarcerated for X number of years. That's what it says. If the state or any prosecuting
59.
agency.
Page 59.
Page 59 of this. Including the court concerned has no wherewithal to provide or protect the fundamental right of an accused to have a speedy trial, which is the procedure part which I was mentioning. Procedure is at the heart of liberty, right? As enshrined in 21, then the state or any other prosecuting agency should not oppose the plea of bail. That's para 17 at 59, on the ground that the crime committed is serious. Article 21 applies irrespective of the nature of the crime. And we may hasten to add that the petitioner is still an accused, not a convict. That's the next paragraph. The overarching postulate of criminal jurisprudence that an accused is presumed to be innocent until proven guilty cannot be brushed aside lightly, howsoever stringent the penal law may be. So, that's the heart of it, man. And I've on the law, anything else?
The last judgment.
The last judgment, Karnataka judgment, I just point out where that.
So the last page.
The last page of this paper, of this compilation. Justice Sundaresh.
Yes, Justice Sundaresh.
Yeah. It's page 173, 1 page before. Yes, 171. Well, 171 of this very compilation. This is this month, mothers. 7th October 2025.
Blast in Karnataka.
The blast in Karnataka. We've heard learned counsel appearing for appellants and counsel appearing for respondent. Appellants have been arraigned as accused for offences punishable under such and such. And under UAPA and Section 2 of the Prevention of Destruction of Property. I mean, here I'm not involved in any of that. We've pursued the charges framed. Appellants have been under incarceration for more than 5 years. There are 254 witnesses to be examined. appellants are two amongst 138 accused persons. Taking note of the affidavit facts, we have no hesitation in setting aside the impugned order and grant bail.
Oh,
So, I'm not going to merits purposely, because otherwise deeply obliged.